23. Now we are going to have a discussion on Employees State Insurance Act 1948 and its provisions. I think I have given you the introduction in the previous clip regarding Employees State Insurance Act 1948. So this provision is also equally relevant as far as the discussion of Employees Compensation Act 1923 is concerned. Reason: in Employees Compensation Act, we have discussed the accident causing the personal injury either happening in the course of employment, out of employment, resulting in either disablement or death. See, when any disablement or death happens, then the question comes regarding compensation. And if there is no insurance provision, like if there is no statutory insurance mechanism, like what happens, it may be extremely burdenful as far as the employer is concerned. He may not be in a position to meet the claims. Reason: he may not have the money. Whether accident will happen causing the injury or death, even that cannot be predicted with any certainty. Of course, when there is no mechanism, when there is no provision made to secure that, even in the event of the accident causing the injury or the death, if there is no provision made to ensure that, ensure that it will be compensated, for compensation no provision is made, then it would be a real burden on the employer that he will have to make a provision even not only for salaries or infrastructure expenditures, but as well for providing compensation. It will be huge, not compensation. Your salary or infrastructural expenditure may be some limit, but this is huge. It depends upon the age at which accident caused and died or disabled. Compensation margin will be very, very huge. Therefore, you avoid your personal liability and invoke these statute provided facilities like insurance. And when it is provided, then you will have the utmost security or safety the employer. So don't think that Employees Compensation Act, where employer is liable for compensation, employer would have made, and in order to save the employer, protect the employer, serve the employer and employment and employees, we have got Esa Act, one of the most prominent supporting enactment, social security, promoting the social security, in which case Esa becomes compulsory. Remember, where 10 or more persons are employed in the 10 or more persons are employed in an industry or establishment, then Esa application is a must. And that too, to whom? Not to all employed in the establishment or industry. It is applicable. It is applicable to all employees who earns a monthly gross payment, monthly gross wages of within 21,000 right now. In the near past, it was like 6,500, increased to 10,000, and now increased to 15,000. 10,000, 15,000, and now increased to 21,000. And there is a proposal to increase it to 25,000 as such. Let it be a proposal right now. We will not refer to that. But 21,000 is what the gross wage limit to all those employees. ESI and its ESI benefits, they are applicable as such. Okay. There are two benefit periods in Esa Act. In administration of ESI benefits. The first benefit period starts from April 1 ending on September 30th. The second benefit period starts from October 1 ending on March 31st. So 6 months each. Why I have referred to you all about these two benefit periods is that in case if an employee who was included within the scheme of the ESI at the commencement of any benefit period, but subsequent to that start of the benefit period, say for example April. In April, your monthly gross was 21,000, therefore within that, therefore you were included within the scheme. But in May or June, your monthly gross increases from 21 to 23. That means you will be going out of the coverage of ESI. But there is one protection. There is one limitation here. During the start of the benefit period, whether it is first or second, if you were the contributory, if you were included within the ESI Act or ESI benefits or ESI scheme, you will not be going out of the ESI scheme during that during the entire part of that benefit period. That benefit period, I said. Though during the said period, since the commencement of the benefit period, if the monthly gross wages of the employee goes beyond the statutory maximum fixed under the Esi Act, that is 21,000. What I mean to say that you will still be covered till the end of. You will still be covered by the ESI provisions till the end of that benefit period. Understand? That means till the end of September 30th. From October 1, you will be covered by a separate insurance provision made by employer towards you and that of your family. That's what I mean. But there is a contribution that also I told you in the previous class. It's 4.75 and 1.75. 4.75 is a contribution to be contributed by the employer on every head of employees, and 1.75 is the contribution to be made by every employee as such. So monthly put together per head, per employee, the total contribution to be deposited to the ESI fund is 6.5% of basic plus DA as such, right? And why it is made also I told you. This will ensure protection. It is a social security measure. Okay, basically it is meant for protection of life and person of employee. I agree, and it is very clear from the benefits. But it is not only employee. Employer is also there. Employment is also there. See, as a result of these kind of protective measures, the loss margin may not be suffered at all, or maybe mitigated at all. And even the loss-like situation happens, employer could still manage to overcome because he is not burdened all these years or months. He is not at all burdened because the provision of ESI was very much there as such. So that's why it is to be introduced. The objectives of Esa Act, that is to pay the benefits as and when the employees are entitled to it. Okay, a fast-paced manner, ESI adjudication of any claims or applications pertaining to claims will have to be at a fast-paced manner. It has to be adjudicated upon, settled upon. 2, 3, to pay adequate compensation as per the Esi Act and administer the benefits to the employees. And 4, all this done, it will promote the social security. Social security provision it is, and social security of whom? Security of employment, security of the employer, security of the employees. I know primarily it is for the ensuring of the security of the employees by guaranteeing these benefits as and when it is accrued. But still I would like to say that when these provisions are introduced by the scheme of employee state insurance scheme, it means that it protects the employment from suffering, it ensures the employer from suffering, and it prevents and protects the employer from suffering, plus it will protect the employees. That's the most important goal. It protects the employee against any perils that may be happening during the course of employment, or some benefits like for women, maternity benefit is not a peril. In fact, it is a divinity. Being a woman is natural, but being a mother is divine, it is said. So therefore, this is a benefit, a facility offered to the woman. Okay, right? Contribution also I mentioned. In respect of each employee, employer to contribute on the basis of his basic plus DA, employer to contribute 4.75 and employee to contribute 1.75. Okay, you have to deposit, you have to collect and deposit every month as such. Then we will go to that administration of ESI. ESI, we have got some 87 sections, right? 1 minute. I will just check. Is it 87 sections? Yeah, it appears to be. Okay, in fact 74 to 81, 74 to 83 dealing with the what is that, adjudication. This is there, ESI code, adjudication and settlement of claims. And in all it covers 87 sections, Esi Act. Why I have referred that these many provisions are there, and these many provisions are directed towards, yes, basically three things. One is contribution, another one is benefit, another one is claims adjudication. These are very, very important. But who will do that? Who will do that? And therefore, you will make monthly contribution, no doubt. Who will make? The employer will make monthly contribution. Even he will deduct even at the time of payment of wages the monthly contribution of even employees. While paying the wages, he will deduct that 1.75% of his total basic plus DA, and it is applicable to all employees 21,000. I also mentioned. But these many provisions are there to ensure that out of the fund, so many expenditures will be there. Out of the fund, though, so pooled, these 6 benefits are to be. So beneficial rule of construction, not strict rule of construction. You cannot render these provisions futile. I mean to say that when the case regarding the claim of any benefit goes to the court, Esi court ought to be beneficial. I mean liberal construction that is required, not strict to construction. These provisions, whether he is a beneficiary, so 1, 2, whether he is a contributory, yes, then why you are so literal? You see, the court or authorities must not seriously, looking in terms of any ground therein you can avoid the liability. No, that is bad. You must always see that how, when he is a contributory, when he is a beneficiary, then you must ensure that what way I can administer the benefit better. So this sort of a tendency should prevail while administering ESI provisions, but while administering these benefits. In case of any dispute regarding the claims, anyhow ESI court, a court specifically established under the Esi Act in sections for 74 to 83 as such right. But now we will have to discuss with the administration of ESI. There should be, see, when you are eligible for maternity benefit, when you are eligible for sickness benefit, when you are eligible for any of the benefit, then it shall be administered. When the application putting forth the claim is made, either before the court or before the employer, see, it should be paid. What is admissible under the act should be paid to the employee himself or that of his dependents. In the case of any dependents, it is dependent benefit and funeral benefit. In every other case, it has to be paid to the employee as such, right? Correct? When it is done, then that administration will be meaningful. What is it for administration we find? Not only these, the mechanism basically, not only these, administration of ESI provisions through ESI Corporation, ESIC, then Standing Committee, SC, and then Medical Benefit Council. No, not only these. Apart from that, you will find Employee State Insurance Corporation, regional or local offices, where local office will have, depending upon the population there, employee population, at the taluk level you will even find ESI dispensaries, ESI hospitals. You understand? ESI dispensaries will be there, ESI hospital will be there, and doctor will be there, every other medical attendant will be there, and the employed section, if you are suffering from any sort of illness, you may subject to the medical examination and treatment there, free of cost. Remember, okay, you should show that ESI card as such, ID card as such. Okay, right? That's what I said. You don't need to go to ESI Corporation situated in Bangalore. No need. That is not required. ESI Corporation is located in Delhi, I said, because there is only one corporation. It administrates the functions through various, and here we have got a regional office, and apart from regional office we have got the ESI offices where it will be headed by the manager. So many are there at each ward level or at each ward level it will be there. At the taluk level it will be there. Depending upon the density of employees or industries, then even they may provide more than one these units, where ESI units, ESI regional offices, they are meant for administration of ESI provisions. Let me tell you, if you have any application to be made to claim in the benefit, why do you go to the ESI court? No, don't go to the ESI court, go to the regional office. of your area nearby, ESI, corporation, office as such. There you make an application regarding any of these. You will be claiming and therefore it will be administering. They will not say no when you are entitled, depending upon the situations. Depending upon the fulfillment of the conditions. Then we have got a standing committee. Then we have got a MBC, Medical Benefit, Council, right? But here, what we require to know is that what is the composition of Employees Insurance Corporation 1948. It has got in all 63. You calculate how 63 comes. How ESI provisions are administered. ESI, you have to write the objectives of ESI in brief and then go to the contributions, all these introduction you have given, then you straight away move to the administration. The ESI provisions are administered by, it will be in charge of ESI Corporation, Employee State Insurance Corporation. In India it is located in Delhi as such, and it performs its functions under the Esi Act through various regional offices and the block offices, and even you find ESI dispensaries headed by, personified by the doctor at medical attendants as such, and even the ultra modern ESI hospitals, they are also established. As far as ESI is concerned, the powers of ESI court are huge, and if we talk about the powers and the functions of the the corporation, it would be like this. But before that, let me also discuss about the composition of ESI Act. As I said, ESI corporation. ESI corporation consisting of 63 members, namely one chairman. Okay, one is chairman, and the second one is vice chairman. Okay, VC, vice chairman. So it goes to 2. Then 5% to be nominated by the central government. It is up to from which sector all to pick and make the member of the ESI corporation, as I am dealing with. One vice president, chairman, vice chairman, one only, but it becomes second one, and third one, 5 members to be nominated by the central government. Okay, this is to be nominated 5 members of 5. Okay, then one each member to represent states, where state will send its representative. In India we have got 29 states. Therefore, each of the states where the ESI Corporation Act, ESI Act is in operation, each of the states where ESI Act is in force, they may send their representative. To ESI Corporation. So we have got 29 states, 29 it becomes, right? Then 10 persons to represent the employers, but the 10 persons are to be appointed by the the central government in consultation with the employers organization. Okay, 10% to represent the employers, to be appointed to be nominated by the central government, but in consultation with the employers organization, and 10 other members to be nominated by the central government. After discussion, 10 persons to be nominated, 10 persons representing employees. Yes, this is important. 10 persons representing employees are to be nominated by the central government, but after consulting the associations, trade union. Okay, then 3 members are to be appointed from 3 members are to be appointed representing medical profession. Okay, 2 members rather, I'm sorry, 2 members are to be appointed representing medical profession as such, and then 3 members to be representing the legislature, 3 members to be representing the legislature as such. Okay, 2 members to be representing the medical profession. Central government will nominate that, but in consultation with their organization. What is that called? Medical Council of India. To be consulted while nominating 2 members from that body. To represent the employers as such. Then 3 members to be representatives to this ESI corporation representing the parliament. When we say parliament, there are 2 houses. At least not more than 2 from upper house. Therefore, that's a limitation. Not more than 2. Therefore, there is a representation to Rajya Sabha. That is very much there. So 3 members representing of these, you can make an arrangement like a parliament. 2 to represent the parliament, Lok Sabha, and 1 to represent the Rajya Sabha, right, upper house. So that way you will find 3 members representing the parliament, and lastly Director General of ESI Corporation, who is an ex officio member. Now you count the total member. Total member you start counting. As I have written there, 63. Who is the last one? Ex officio a member. He is called Director General of ESI Corporation. So now you can count. ESI Corporation is a mechanism for administration of ESI provisions. It consists of 63 members, namely chairman, vice chairman, 5% to be nominated by the central government, 1 each from representing the state to be appointed, then that becomes 29. So right now only we have got about how many done? We have got done 1, 2, 3, and this is 5, 8, and this is 29. So we have got done with the 37 composition, and 10 each to represent employer and employee in that manner I told. So it becomes now 57. Then we have got 2 to represent 2 to be representing medical profession, 59. Then we have got 3 to represent parliament, of which 2 other members should be representing the Lok Sabha. So 62, and last one ex officio member, he is called Director General of ESI Corporation. So ESI Corporation normally consists of 63 members, hence therefore, okay. And what are their powers? The powers of ESI Corporation is to 1. Power to promote measures of health, correct? Power to promote measures of health, it exists for that. Remember, in times of accident or any other natural or man-made activity or whatever, any accident happening, thereby injury, or even the case of death, whatever. In the case of injury, you must be provided with adequate measures for medical examination, treatment, etc., etc. Even your monetary needs are to be taken care of, because it's accident causing the injury. Done. So therefore, what I am telling is that ESI has got plenty of powers, like power to promote health measures, power to accept the grants. If anybody, any of you, if they are willing to contribute to the ESI fund, they may do so. Hey, not as employee whose monthly wage is within the limit of the 21,000, but as some sort of what we can say, there is a word who contribute, what is that word? It's gone. It's very important word. I will get it as and when it comes. So you find about 63. Total 63 members are there in ESI, whose ESI powers are the following. 1. Power to promote measures for health. The word I was trying to find is philanthropist. A philanthropist, right? 1 is that power to promote measures for health. You keep measuring, you keep inventing, you keep improving these measures, these provisions. Then power to accept grants, as and when the grant may be coming from the corporate sector, from the other sector, from the government sector, from the employer sector, from whoever. Any grants are made to you, please accept. You have got the power to accept, Mr. ESI Corporation. Power to hold, because you are a corporation, you are a distinct legal entity. And when you are a distinct legal entity, you are entitled to hold, dispose of, or acquire immovable or movable property in your own name, in the name of Esi Corporation as such. So there is a word where what I said is that the power to hold the property in its own name, both movable or immovable. And then we have got establishment and maintenance of hospitals by the corporation. It's a responsibility of yours to establish and maintain hospital at such and such places. Simply providing for an exceptional hospital is not enough, as we have seen. And we have, it is not a criticism, I don't want to quote it as such. the concerned minister, just because it is his hometown, just because it is her hometown, he or she should not go for constituting the important offices in their own district. No, they have to be more of a societal in mind, in the sense where its presence is where its presence is absolutely essential, where its presence is reasonably good, then at such places you have to establish. So I would say Karnataka, if it is, then it should be in the more or less in the central part. I think if it is in Bangalore, then Bangalore will be always ideal, because all offices are very much available in Bangalore. All facilities are also as well available. Therefore, but it is up to the state government to establish the ESI hospitals, ESI dispensaries at such places as they deem fit. Then we have got the power to frame regulations. ESI even has got the power to frame regulations for the administration of ESI in a better way, right? These are all the powers and functions of ESI corporation as such, whose offices, some offices like the chairman, the vice chairman, the 5 representatives nominated by the central government, and the Director General of ESI Corporation. Director General of ESI Corporation is the ex officio member for this ESI Corporation. What I meant is that chairman, vice chairman, and the 5 other members nominated by central government, these people will hold the office at the pleasure of the central government. As far as the other, even the 29 members representing each of the states, one each, they will be holding the office at the pleasure of the state government. If the state government is not willing them to continue in the office, if they recall by notice to the central government, then recalled and should be replaced. That's what I said. I said that as far as the administration of ESI corporation is concerned, that persons appointed will enjoy, some will enjoy fixed tenure, like they are appointed for a period of 4 years, like as I said, the who are they? The 10 members nominated by the central government in consultation with the employer organization, in consultation with the employees organization, other 10, then 3 from medical, 3 from parliament. Okay, these are all will hold the office for a particular period of 4 years. They are eligible for renomination. That is what said. And the standing committee will consist of 16 members, and these are formed from the ESI corporation itself. And what all those standing committee what is it standing committee composition, namely the chairman. The standing committee shall be constituted from amongst the members of the corporation, and it will consist of the following number. The standing committee shall be constituted from ESI corporation, and its membership is allotted in the following manner. 1 chairman, 2 3 members of the corporation, 1 chairman, 3 3 members of the corporation, where I have mentioned 2 members are there, from that 2 will be 5 are there, 2 members to be nominated by the central government. From that 2 will be allotted to this what is that called, standing committee. Then 3 members of the corporation representing 3 members of the corporation representing such 3 state governments as the central government may by notification gazette specify from time to time. So you got to know total 5. As far as the standing committee composition is concerned, 1 is chairperson, second one is 3 members of the corporation from 5. Okay, 3 members of the corporation. The third one is that representing 3 members of the corporation representing the states. 3 members of the corporation representing the state. What is the other composition? 3 members represent the employees to be nominated in consultation with the employer's organization. Then next one, 3 members representing employer, but those are to be made in consultation with the employer's organization. Okay. Then we have got what is that? Two members representing the parliament. Two members representing the parliament as such. Okay. Rather one member. Okay. One member to represent medical benefit. Medical profession, and one member to represent parliament. Like that you will find. So I said one chairman, 3 members to represent the states out of 10. Then out of 10 I said out of 5, 3 members to be. Then 3 members to be to the what is that called to the state representation. 3 members to be nominated by the central government in consultation with the state government. This is what. Then you have got 3 members representing employers, and what is that? 1 member representing a corporation and 1 member representing one member representing from among the corporation elected by the parliament as such. So this way you will find total 1 Director General of ESI Corporation, Director General of the ESI Corporation shall be ex officio member of the standing committee. Second one, the 8 members will be elected by the corporation. 8 members will be elected by the corporation as follows. Okay, how it is? One is that chairman. One is the where I mentioned. One is that chairman. Second one is that 3 members of the corporation representing 3 such states. Of course, that other states will have their membership on rotation basis. And the Director General of ESI Corporation shall be ex officio member. So in all, how much you got it now? Up to now, 1. What is that? 1 is the chairman, and this is 3 members representing corporation. Therefore, it goes to 4. Then you will have 3 members representing corporation. The first one chairman, second one 3 members of the corporation, and the third one 3 members of the corporation representing employer or employer's organization, and fourth one 3 members representing employee or their in consultation with the organization of that central government will be nominating, and then 1 member from among the members of the corporation representing the medical profession. 1 member from the medical profession. 1 member from the parliament. How much it becomes? Chairman 1, and then 3 members representing the 3 members to be nominated by the central government. It goes to 4, and then 3 members only representation to be provided to the state. So 3 members to be appointed, nominated by the state, by the ESI Corporation, nominated by the central government to the ESI Corporation, but in consultation with the what is that? Those 3 members are to be appointed, but in consultation with the employer's organization. 3 members are to be appointed representing the agent, representing the employees, but in consultation as far as possible of the trade union, and 2 members. 1 member from the medical profession, 1 member from the parliament as such. Now, how many total composition you can see? 1, 3, 4, 3, 7, 3, 10, 3, 13, 1, 14. But how come that it is? There are some other members like 1, total 3 members of the corporation, 3 members representing the state. It goes to 7, and 1, 3, 7 plus. Here 3A, right? Director General of ESI Corporation. Director General of ESI Corporation shall be the ex officio member of the ESI Corporation as such. They shall be ex officio member of the ESI Corporation as such. So in all, right now you found 8 members. In all, you find 8 members, and then again we have got 3 members to be appointed by the central government in consultation with the employers organization. Likewise, 3 from employers employees organization, and 1 each from the profession as well as the parliament. So therefore, the parliament, when I say one, it must be, from the elected house of the parliament. So totally, we have got 16, 8 plus 8, it becomes 16 members. They shall be picked, you understand. The standing committee will have 16 members in the form of chairman, vice chairman, chairman, 3 members to be nominated by the central government, 3 members to be representing the states, 3 members only to represent the, states as such, and then Director General of Esa Corporation. In all, it makes 8, and there are 8 more, namely 1 Director General of Corporation, 2 the 8 members elected by the central government, but in consultation with the employers organization, 3 employees organization, 3, and 2 from one each from medical profession, and what is that called, parliament. Instead, even in the second part, you will deal with the 8 more. So in the first part, chairman, 3 members representing the corporation, 3 members representing only 3 states, no other representation, and Director General of Esa Corporation. Total, it goes to 8. And the remaining 8 members are 1, 3 members to be representing employer, goes to now 11. 3 members representing employees, goes to 14. 1 each to represent the medical profession and English Parliament. So totally 18 are there. 16 members are there as far as the standing committee is concerned. 16 members are very much there as the standing committee. What is the purpose of the standing committee? No doubt, administration of the standing committee, corporation, and then subject to the general control of the corporation, it may exercise the powers and perform the functions of the corporation. Then subject to the consideration, it may subject to the general control of the corporation, it may exercise any powers and functions and perform any other functions of the corporation. Then it shall submit for consideration and decision of the corporation any matters pertaining to ESI or any matter pertaining to the provisions in this behalf under the Act of ESI, and it may also submit for consideration and decision and approval. It may also submit for the approval of the corporation any of the cases pertaining to the administration of ESI Corporation Act as such. Okay, ESI Act as such, right? And then lastly, the standing committee may also at its discretion submit any other case or matter for the decision of the corporation. So ultimately, for the decision of the corporation, for the approval of the corporation, you may submit for their consideration and decision any any of the case or any other matter. This is what. So overall supervision, overall administration of ESI Act, overall administration of ESI Corporation, and overall the rule making authority, they are all to be exercised by the standing committee of the corporation comprising of 16 members. Then we have got, as you know, Medical Benefit Council. There are a medical benefit when it occurs in our mind, we will think of such benefits are absolutely needed. Why? Because look at these benefits. Medical benefit, sickness benefit, disablement benefit, maternity benefit, dependent benefit or funeral benefit. In each case, doctor's role is there. Who says that in one of the benefit doctor role is not there? No. One way, even to declare a person is died, even to declare a person has suffered disablement, permanent, total, partial, temporary, etc., you require the doctor. Even to declare that the dependent, law is very much there, but any examination is needed, then it has to be sent to the medical examiner only. That is the reason why I am telling you that there are so many provisions where medical benefit council's role is huge. And what is that medical benefit council's role? It may it will consist of members whose number is 41 in all. And overall, the total composition of the medical benefit council is 41. Let me now figure them with the one medical benefit council will comprise of 41 members. Who are all they? 1 Director General of Health Services of ESI Corporation. 2 Medical Commissioner of ESI Corporation. Director General of Health Services, Medical Commissioner of the ESI Corporation shall be the ex officio member. It means there you will see who is the ex officio member of the corporation? Director General of yes. Who is the ex officio member of the Medical Benefit Council? Even in the standing committee, Director General of ESI Corporation, since he is there, he is the ex officio member of the standing committee. But as far as the medical benefit is concerned, the ex officio member of the Medical Benefit Council is a medical commissioner. So second member he is, and the third member is Deputy Director of Health Services, third member, and then we have got 20 a member each representing the states. A member each to be representing the states to the Medical Benefit Council. It takes the total composition of the Medical Benefit Council to 32 now. And then we have got 3 members each to be nominated by the central government in consultation with their respective organization. Say for example, 3 members representing the employer organization, 3 members representing the employees organization, and 3 members representing the medical profession, but only in consultation with the organization of medical profession. In India, we have that organization called the Medical Council of India. Okay, so it goes to total, out of the 3 members representing medical profession, not less than 1 of these members shall be a woman. Understand? So out of 41, 1 person is guaranteed that she is going to be a woman. She is going to be a female member. And especially that member of the medical profession, 3 members, out of that at least 1. If you want to appoint all 3, fine, but at least 1 of them shall be woman. From 3 members representing medical profession to be nominated by the central government in consultation with the medical organization of the medical profession. In India we have that MCI, but out of those 3, 1 shall be woman. But there is no bar that all 3 shall be women. No, you can. 2 women, 3 women, it is up to you only there. Okay. Then in a total number of this Medical Benefit Council, as I said, the Director General of Health Services, and then Medical Commissioner, ex officio member, then Deputy Director of Health Services. Okay, 3 it is. Then 29, 1 each member to be representing the states other than the union territory. Therefore, in this Medical Benefit Council, there is no representation to the union territory. So, how much it is now? 32. Then 3 members each representing, nominated by the central government, representing employer, employee, medical profession. And in that last medical profession, at least 1 shall be woman, they say. So, total it goes to 3, 41. What are their powers and functions? Medical Benefit Council. That is what important. As I said, the Director General of Health Services, the Medical Commissioner, the Deputy Director of Health Services, they are appointed, they hold the office, even a member representing the, states, they hold the office at the pleasure of their government. But as far as the representatives of the employer, employee and medical profession, in the Medical Benefit Council, their tenure is 4 years and could be renominated as again. Okay, and they will hold the office for a period of 4 years. When the 4-year term ends, there is the question. They could be considered for renomination as well, or they can continue in the office till the new appointment is made. So that is the case. As far as the tenure of standing committee members is concerned, the chairman, 3 members of the corporation, 3 members of the corporation representing 3 such state governments, and the Director General of Health, Director General of Corporation with the ex officio member, other all members will enjoy the office at the pleasure of the central government. And remaining members, 8 in the standing committee, like 3 members representing employer, 3 members representing employee, 1 to represent each this parliament and medical profession, they will hold the office for a period of 2 years. Okay. They are entitled to be renominated as well, provided they are good enough, qualified enough, they are eligible enough for renomination. As I said, if I am a member of the parliament, now I will have 1.5 years tenure. See, when my first tenure ends, I will not be a member of the parliament. How can I be considered for renomination? Not possible. Therefore, you can be renominated only when your parliamentary or legislative term is there, otherwise not possible. And what are the duties of a medical benefit council? As I said, to advise the corporation and standing committee on the matters relating to administration of medical benefit, certification of medical certificate, and then a grant of benefit and other connected matters. And then they have all the powers and duties of investigation, as may be mentioned with reference to the complaints against the medical practitioners who are administering the various benefits under the Esi Act regarding medical benefit, regarding medical treatment, regarding attendance, etc. Then they can perform other duties in connection with the medical treatment and attendance as may be specified in the regulations. But remember that a medical superintendent, that medical commissioner, that Director General of Health Services don't confine to the office as such. You have to conduct surprise inspections because you have got many your own hospitals in existence. As far as the Karnataka is concerned, we have got in Gulbarga the ultra modern with all new technologies. An hospital was established when the MP from the same area was the Labour Minister of India. Okay, that time. And you will see the ESI Corporation was established and Medical Benefit Council, whose job is to provide ESI Corporation. No, not ESI Corporation. ESI Hospital with ultra facilities provided and established and provided there in Gulbarga. And if there is a they have spent a huge, crores of money being invested in establishing the hospital and procuring the medical equipments. And also so many employees, posted there. Now you require lots of expenditures, but the medical professionals, if they show negligence in providing medical treatment and all, this is the utter this is the utter carelessness, negligence, misconduct on the part of the doctor. And Medical Benefit Council, you should ensure that everything regarding the medical administration, regarding the medical treatment, regarding the medical benefit administration, all these are to be reaching properly. That has to be ensured. This is what the what we can say mechanism provided. What are the benefits provided? Now I will quickly peruse through the benefits provided under the Esi Act. As I told you right now, ESI provisions are administered by a mechanism comprising of ESI Corporation, and it consists of 63 members. The tenure of the office of many are 4 years, eligible for renomination, and then some others like chairman, vice chairman, state representative, 5 nominated, they will enjoy the office only at the pleasure of the government, central government, whose powers also you have come to know. What is that? The powers of ESI Corporation is consisting in power to accept grants, power to administer the ESI, power to make rules, power to establish hospitals, so many like that. Okay. Then the standing committee consisting of 16 members. Okay. The first 8 members will have the office at the pleasure of the government. The second 8 members will hold the office for a period of 2 years. Right. And as far as the medical benefit is concerned, consisting of 41 members. And out of that, the first 8 members, 29 members representing 1 each of the states other than the union territories, and the medical commissioner, the Director General of Health Services, and the Deputy Director of Health Services, they enjoy the office at the pleasure of the government appointing them, and the three members representing employees, employer, and the medical profession will once appointed to this medical benefit council will hold the office for a period of 4 years, and they are eligible for renomination. That's the one. Second one, in case if the renomination is not made, when their tenure ends, 4 years tenure ends, if the renomination is not made, they will continue to hold the said office for such further period till the new nomination is made, right? Or they could be renominated, right? Their powers also, I said, medical benefit council's powers must be connected with or designed towards promoting medical benefits, administration of medical benefits, treatment, etc. to ensure that hospitals or dispensaries established here and there as per the provisions, they must be adequately equipped enough, they must be adequately efficiently managed enough, and there should not be any complaints regarding their malfunctioning or negligence, etc. etc. Then why ESI? See, mechanism is provided. You know that the contributions paid by the employer and employee, that is 4.75 plus 1.75, 6.5, every month it goes to all the employees whose monthly total gross is within 21,000. You know that all these money is not contributed by each employee supported by employer's contribution, not for paying salaries or allowances to these ESI or standing committee or medical benefit council. They are, so of course, no, these are not intended for your salary. Don't think that this is this money you can enjoy for your expenditure. No, your expenditure is needed, but when many number of members there, and how much of expenditures will be incurred in your own administration, you must be very cautious, you must be very serious about that. Therefore, you must function quite effectively, and your function is directed towards promoting the administration of various benefits. What are those benefits? Medical benefits. What medical benefits? Full, whatever expenditure that is incurred, you are an insured member because you are contributory. And whatever expenditure that is incurred for the purpose of your treatment, then all such expenditures without any limit, they are to be administered. Okay? And sickness. No, if the sickness is there for 3 days, then you are not eligible for any compensation. But exceeds, yes, you are entitled for sickness benefit at the rate of, I think, 70% of the wages. Sickness benefit. Sickness benefit could be extended. Sickness benefit could be expanded. If it is, there is 70% of your wages will be paid. There is no limitation as such, and it could be extended by some more periods. And it can also be enhanced. Instead of 70% of the wages, full wages. So those will be there. Okay. But suppose if you undergo one sickness benefit period and finished, got the benefit, the rule. I am just talking about the rule. Exception is always there. But when we talk about the rule, in case if any recurrence or if the sickness relapses or some other sickness comes, you will again take sickness leave and you will be taken to the hospital. But when you just finished the sickness period, sickness treatment, whatever, and after finishing that you have reported to the work. Okay, immediately after about 4 to 5 days or 8 days or 10 days, again you are affected with another same or another sickness, whatever. 10 days only. But law says, see, this is there. You will be allowed medical benefit. But what rule says, between one benefit to another benefit, the gap should be 15 days. For administration, see, sickness benefit administration is to, if the law is to be taken note of, then between one sickness benefit to another sickness benefit, there should be a 15 days gap. But as I said, this is the rule. But exception rules the rule. Okay, when I say exception rules the rule, it means that if you are affected with another sickness, immediately following that first, no problem. You are a contributory and you are not fraudulently seeking, you are affected by sickness, doctor certifying, you will be provided with that. Okay, then funeral. If you refer to old books, you will find it is about 1,000 rupees, enhanced to 2,000 rupees, enhanced further to 3,000 rupees, enhanced further to 5,000 rupees, and in the year 2011 enhanced to 10,000 rupees, and in the year 2019 March 1 it is enhanced to 15,000 rupees funeral benefit. To whom? To the person who has actually performed the funeral. It need not be any relative. Understand? Who performed the funeral? Who incurred the expenditure for performing the funeral? With the documents you come within 6 months. As I said again, 6 months is not a period of limitation maybe, but if you give genuine reasons for the delay, it could be entertained because you have performed, you have the proof. Then even if you come delay beyond that 6 months, you will still be allowed to get that 15,000 funeral benefits. Then disablement benefit. What is a disablement? There is permanent total disablement. There is temporary total disablement. Total disablement and temporary disablement. Disablement benefit will obviously administered at the rate of 90% of the wages. You understand? At the rate of 90% of the wages from the day one of your employment, and irrespective of having paid any contribution in case of an employment injury, if you are disabled, temporary total disablement benefit will be administered at the rate of 90% of the wages, payable as long as your disability continues. And see, a person met with an accident in the course of the employment, the accident means car accident or this accident, somehow, if he is met with an accident resulting in the disablement, then you will be paying disablement benefit at the rate of 90% of the wages only for 3 weeks. Nonsense provision it is, if at all it is there. Therefore, there should not be any time stipulation for administration of the disablement benefit. Why? When the doctor is treating and saying that he is disabled, then till he is fit enough to resume the work, till he is fit enough after curing, after a complete recovery, you should administer the disablement benefit. And when he is there in the disablement benefit, you have to pay this 90% of the wages. And as I said while discussing about Employees Compensation Act, in the case of permanent, generally, what is that? Something happens, some serious accident happens. Say for example, my arm got broken from any level, or from knee level, my leg got something like. The treatment will move on and on for a longer period. When the treatment goes on a longer period, say for example, there are cases to prove that you were under the medical treatment for almost 1 year. That time you are disabled. That time you are under treatment. That time you are paid 90% of the wages. That is needed for your family to be taken care of, you to be taken care of, and plus one more minute, you are entitled to medical benefit and all. When the disablement benefit is paid, don't be under the impression that that disablement includes even medical treatment. No, that is different. There are some benefits you cannot club. Law has clearly stated in section 60 something, 60 or 61. They like maternity benefit and sickness benefit and medical benefit. Then dependent benefit and there is one more, disablement benefit. These cannot be clubbed. There are certain benefits, 6 benefits are there. Some benefits, as I simply gave, sickness benefit and maternity benefit cannot be clubbed. Remember, it cannot be clubbed. And you are not eligible at one and the same time for more benefit than one. Those are the restrictions that you will always find. Okay, disablement benefit, I said. What is the total disablement comes? Say for example, when both the legs gone, I am entitled to 100% disablement. In the sense, if a person dies, how he is entitled to 100% disablement? And then how is entitled to that, compensation in the case of death? Likewise, I will tell you, in the case of death of the employee would be entitled to 50% of the wages multiplied by the relevant factor as compensation. But in case of the employee lives but as good as dead, in the sense, I cannot move on, I lost eyes both, I lost my legs both, in which case 100% disablement is there. So I am eligible for what compensation? I am eligible for 60% of my wages multiplied by relevant factor. Relevant factor, when I am grown of age, relevant factor is lesser. When I am young, relevant factor is more. Or minimum of 1,40,000 as we have seen in the Employees Compensation Act. You got it. Employee Compensation Act says that. And that is equally applicable here in times. And when, what is that total disablement comes? As I said, what is it? 60% of the wages in case of disablement, 60. In case of death, 50%. 60% of the wages multiplied by relevant factor. How much it comes? Calculate. When you have calculated whatever amount comes, that is the amount payable by way of compensation in the case of disablement. But what is the disablement? Doctor will certify. If the disablement happens to be some 30% loss, partial disablement or 60% loss, then you got to know 60% of the wages multiplied by relevant factor. This is the amount of this is the compensation in the case of total disablement. Out of that, that is the calculation, okay, generally. But you are not entitled to full because your loss of earning capacity is only 30%. Therefore, of that amount, 60% of the wages multiplied by relevant factor, it produces what amount? Of that amount, you will be entitled to get only 30%. So that way it is calculable. One more, and during the course of your treatment, if you are paid with the half monthly payment, if these will be, when the final is decided, these will be deducted. But anyhow, the medical benefit could be administered according to whatever medical expenditure that is incurred. These are all over and above that, and that is the duty of the ESI hospitals. Whatever they incur expenditures cannot be deducted while administering the benefits as such. Then maternity benefit. Maternity benefit you can think of. I am not going to refer the text of maternity benefit. It is not required. But let me tell you, from the date on which it is proved that she has conceived, from that date till the date the surgeon, the medical practitioner who treated her, he or she certifies that she is fit and is able to resume, till that date, no question of any notice can be served by the employer. No question of any action can be taken by the employer. You understand? There are many that if I would give the cases like from the date of her conception, some sort of a sickness, some sort of uneasiness. So she may have to be subjected to some medical benefit. She goes on leave. This interrupted the work. Employer treats, hey, you are going on uninterrupted number of leave. This is quite disturbing the continuity of employment. Why you can't be? Or after delivery, after finishing in the olden days, if you are thinking about some 2 years back, the maternity benefit was for 12 weeks, and 12 weeks time ended. But you did not turn up, and employer issuing the notice. See, your maternity benefit, we know that you underwent the maternity benefit period, and in spite of having finished 12 weeks, you did not still report. Therefore, it is a serious indiscipline action. Why can't the action be taken against you? A show cause notice, if it is issued, then on the basis of that show cause notice only, you go to the ESI court. No, employer, you cannot do it, because now you will be, as far as her is concerned, you will be at the mercy of the doctor who treated. If the doctor certifies certified fit, but then she did not report, you are right. But till doctor certifies that she is able to resume, she is fit enough to resume the work, no question of any action that could be taken by the employer. Employers is violating the provision, he will be attracting the penalty ranging from 1,500 to 7,500 as the case may be. Okay, and if he repeats that, then he will be liable to undergo imprisonment as well. We have not seen that imprisonment penalty imposed by the court that seriously, but penalties are very much this 1.5 to 7.5 sort of the quantum or volume of a penalty It was not there earlier. It was there earlier 200 to 1000, but now it is enhanced. Okay. Then any other benefit? Medical benefit, sickness benefit, funeral, dependent. Dependent benefit means when the employer dies, either in the course of employment due to their accident causing the person resulting in the death, either in the course of employment, time of employment, place of employment, or out of employment, even beyond the time of employment, place of employment, then the dependent. Who is dependent? Yes, I defined and I have defined it. The dependents are three categories of dependent. Like dependent means any class of the following relatives who are dependent either wholly or in part dependent at the time of employee's death. Namely, first category, as I said, I'll just state one. First category, widow, minor legitimate son or adopted, unmarried legitimate daughter. Minor will not come in case of daughter, because even if she is a major, not married, she'll continue to be the dependent. She'll continue till her death. But if she gets married after majority, again, if she marries in minority, even after marriage, she'll continue to be the dependent. But if she marries during majority, then she will lose the dependent status. But still she can come back to the dependent status. How you know? After majority, she is married, and after marriage, her husband and entire family died, leaving nothing. She will come back. Okay? Yes. Then there is one more, widowed mother in the first category. Second category, minor legitimate or illegitimate son or adopted, unmarried legitimate daughter or illegitimate or adopted, but infirm. Infirm means unsoundness. And third category you will find. The people like widower and so many grandparents, children of predeceased daughter, predeceased son, so many things it will come. Oh, they are dependent. Such class of dependent. If there is one person in the, say, if widow there, if he dies, if his widow is there, then we will not think, we will never go beyond. If one is there in the first category, we will not look to the second and third category. If nobody is there in the first and second, we will look to the third category. That is what dependent benefit. What is the benefit? 90% the wages shall become payable to the dependent. If an employee dies, in the course of arising out of something like to their life, 90% of wages becomes payable. But there are conditions, kindly refer to the same. Okay. And then lastly, I will refer ESI court. ESI court says, why ESI court? For disposal of claims, for adjudication of claims. What claims? There are, as I mentioned. Now I have to. As I mentioned, claims like whether the person claiming the benefit, okay, whether the person claiming the benefit, whether he is employee. Who is employee? I am also employee, but I am earning a salary of 25,000. Will I be included within the ambit of employee? No. As far as the Esa Act is concerned, persons who draw monthly wages gross, if it is 21,000 as I said, then only. But if any person goes beyond the monthly gross of 21,000, then he will be out of the coverage, and he is not employee within the meaning of ESI for all this. You understand? But as I said, if his monthly income, if his wages exceeds that 21,000, when at the start of the benefit period, there are two benefit periods I told you. First one starts from April 1 to 30th of September. Second one starts from October 1 to March 31st. Okay. Any benefit period you give me. Oh, second benefit period. Right. At the start of the second benefit period, that is in October, my monthly wages was 21,000. Therefore, I am covered. But in November, my salary or wages got increased. It is now 28,000. Okay. It was 21 in October, but in November, as a result of revision, my wages got increased to 28,000. Will I be an employee? If the employer says, hey, I need not administer ESI benefits because you are out of the coverage, you are no more employee. I know you are employee of mine. You are covered by special insurance scheme which I will, anyhow is there. Those employees in the establishment whose monthly wages is beyond 21,000, then employer will provide insurance provisions to each one of them. Otherwise it will be liability for the employer. But ESI provisions are administrable only to persons within. But as I said, he will be entitled, he or she, whose monthly wages at the start of the second benefit period was 21,000, but very next month goes to 28. Actually speaking, they will be going out of the coverage. But no worry, at the start of the benefit period, since you were there, you will continue to be covered by the ESI, security, ESI, benefits. As and it is needed, you will continue to be covered. No contribution will be made by you from October onwards. October you pay, November onwards no contribution from your side. But November, December, January, February, March, you will be continue to be covered by ESI scheme. Simply reason you are there at the start of the subsequent variation in the wages will not alter your eligibility to the benefits. You will continue to be covered by the scheme till the end of the benefit period. You understand? Right, that's one thing. Then next, whether he is an employee, a claim may be there. Employer says you are not employee. I say that I am employee. And I and you cannot decide. Let it go to employee state insurance court. Who has established? The state government will establish a employees state insurance court, ESI court, where we have in Nirpatunga Road near that criminal court complex. We have that ESI court, employee state insurance court, and it is presided by the state government. Will appoint whom? It will appoint any person. Either he is or has been a judge for a period of judge and high court judge. It's not high court judge, a district judge for a period of 5 years, or any person who is holding a judicial office for a period of 5 years, or it is also some more like I'll tell you, even a legal practitioner. You understand? A legal practitioner, a judicial officer or a legal practitioner having 5 years of experience in their respective field, that is enough to be for a person to be appointed as the presiding officer of a ESI court. And how many courts are required to be there? Depends. If the government of the particular state has constituted more courts than one, then suppose as usual you have come to Bangalore. When the court is established in Gulbarga, then that is your designated court. Why did you come here? Why did you come here from Gadag? North Karnataka, it is Gulbarga. Now, in case if you come and file that claim before Bangalore, then what? It can be either disposed of Bangalore ESI court, or Bangalore ESI court may transfer it to Gulbarga. Okay, that is possible. Then, as I said, when the claims will have to be made. What claim? As I said, whether you are employee. Second question, what is the rate of wages? Rate of wages, as I said, at what particular benefit to be administered, rate of wages. What is that wage? The wage is 21,000. Latest, what is that? That is to be considered. And at what rate? Yes. Who will have to determine? Not me or you, but the ESI court in case of dispute. Then regarding contribution. Contribution either paying less or not paying or not crediting. See, you have taken employee. It so happens we have many instances when we study the cases. We will see employer has collected, deducted at the time of payment of wages all these contributions. His own contribution that is applicable 4.75% depending upon each and every head, plus the contributions which you have deducted at the time of payment of wages in respect of each employees, you did not credit it all to the ESI fund. It so happened even in the case of PF. You are all under the impression that we are covered by PF, we are covered by EPF, we are covered by ESI, but it is not so. Employer has committed fraud. It's a crime, but ESI can decide that. And he is liable for penalty, imprisonment. That is what I said. And imprisonment may even be, prosecution can be there according to IPC due to fraud. Then, right to claim, what is that? Right to any claim of benefits and its duration. sickness benefit, medical benefit, etc. Write to those claims and what is the duration. Employer cannot decide the duration. Nobody can decide the duration. It is based on the medical certification. The duration of the benefits will be decided. And then regarding who is employer, who is the principal employer, there are possibilities that employer will evade the responsibility, saying that it's not in my control. Who is the principal employer? Okay, this can be determined by ESI court. And regarding then claim to recover the benefit, it is also possible when we go to the regional offices with all the documents that I am entitled to this benefit, that benefit. First possible, a woman employee after undergoing the maternity, she resumed the work on the certification of the surgeon. She goes, I am giving one simple example. Her colleague asked, how much maternity benefit you got? Oh, even maternity benefit will be administered. I did not do the work during the today. What is that maternity? I lost the track. Maternity benefit will be administered. I have not at all spoken about maternity benefit. I'll just get you the points, then I'll come back. Maternity benefit from the date of conception till the date of her fitness resumes after undergoing the treatment, after undergoing the maternity. No action can be taken by the employer. Leave will be granted. Maternity benefit earlier was 12 weeks, but now it is increased to 26 weeks. In addition to that 26 weeks, she is also entitled, in case if she is not fit enough still, she will be entitled to one more month's maternity leave as well as the benefit, and it will be at the full rate. Understand? And then you can as far as describing the maternity benefits, say for example, the mother dies, child survives. Child dies, mother survives. Both die. What is the maternity benefit? In case if both die, dependent will be entitled up to the time of death, maternity benefit. In case if the mother dies, then the child survives, maternity benefit will be administered to full length plus if any. Child dies, mother there, maternity benefit will be administered to the full. Though the child is not there, she had delivered but the child dies, maternity benefit will be administered to the full extent. Understand? This you please. And what I was trying to tell you is that, in case in that we see in the offices, regional offices of ESI, they are denying benefits or indulging in corruption or some sort of negligence delay. File the claim before the ESI court. Understand? Right. You are eligible, for those claims to be filed. And such claims you can file when the limitation period to file the claims arising out of under the provisions of Esi Act is 3 years. Okay? And when the ESI court, when you can file 3 years, even the condonation of delay is admissible. Okay? From the date of cause of action, from the date on which you are eligible to benefits, if there is any claim, then from the date of that, within 3 years you have to file. ESI court decided. You filed the application comprising of a claim, filed, ESI court decided on a fast track basis. Okay? ESI court is a court specifically designed to entertain ESI claims only, nothing else. Okay? Then, if a decision is not satisfying one, either the government may challenge it, or the employer may challenge it, or the employee may challenge it. Where to challenge on appeal? It is challengeable before the High Court within 60 days from the date of passing the order by the ESI court. As I said, penalties ranging. What for penalties? Employer not paying, employer not implementing, then the ESI regional officers, they are not, they are indulging in sort of negligence, corruption, etc. And they are not allowing the inspectors. There is a provision which I did not refer to. Inspectors are appointed under each and every provision. Normally, the function of inspector under ESI, under factory. So when I discuss with reference to factory, section 8 and 9 speaks about, I can quote. But inspector comes under this act, inspector is there, provision for constitution under section, I think some 36 or 39. Inspector is appointed. Inspector duty. What is that inspector duty? To enter, conduct inspection, examine records, examine persons over there, and ascertain whether these provisions are administered properly and all. Correct? And now, when they come to know that, oh, there is some falsity, got it? Yes, that time it is essential. When inspector is conducting inspection and employer or anyone concerned, they got to know that this inspector will come to know, they interrupt, they affect, they disturb, they interfere, so as to disturb the inspector in the conducting of inspection. If at all you disrupt the inspector in conducting of inspections, you will be liable for penalty. As I said, the penalty in the range of 1,500 to 7,500. Repeated offences will attract imprisonment up to the range of 1 year. Hello dear friends. See, in the course of my discussion with reference to the contributions under Esi Act, that is part of Unit 4 to Labour Law 1. That is the second part of Unit 4. First part is ECA, Employees Compensation Act 1923. And the second enactment, second part of that Unit 4 is Employees State Insurance Act 1948. It has got so many provisions, as I said, the objectives, contributions, the mechanism provided for the administration of ESI, namely ESI Corporation, Standing Committee, Medical Benefit Council, inspectors, and one more, that is for adjudication of any claims or petitions under Esi Act. If any claims arises, then that can be referred to ESI court under section 74 to 83 of Esi Act, right? But there, in the course of my explanation, I told that the contribution to be all the employees to whom it is applicable. It is applicable to all employees in the industrial establishment whose monthly gross wages not exceeding the 21,000. Of course, it is getting updated from time to time, but right now it stands at 21,000. Your monthly gross wages will be 21,000, and if it is 21,000, then you are covered. You become under the Esa Act, you become the insured member. But to become an insured member, you have to contribute. Even employer will contribute. How many employees are there in your establishment? Say, for example, if there are 100 employees there in the industrial establishment, out of that, those 100, how many are there within 21,000? There are about 35. 35 employees are, out of 100 employees, there are 35 employees who are covered by this Esi Act. Why? Because their monthly wages, gross wages is 21,000 or less than that. If you are going beyond 21,000, then you will not be covered by Esi Act. Employer will provide a separate insurance facility for you. And to avail this, to be covered by this ESI scheme, Employee State Insurance Scheme, which offers several benefits like sickness benefit, medical benefit, dependent benefit, disablement benefit, maternity benefit, and funeral benefit. To be covered by ESI scheme, so as to be entitled to these schemes benefits, you have to be contributing. What is that contribution? The responsibility, ultimate responsibility to contribute to the ESI fund for the head of each of the employee, it is 3.25. Employer will have to contribute 3.25 in respect of each employees whose monthly wages up to 21,000, they are covered by it, So in respect of each employee, according to his wages within that limit, gross wages within that limit, you have to contribute 3.25% of that employee's total wages. Whereas employee will contribute only 0.75%. So totally there will be 4% in respect of each employees who are covered by, who are to be applicable to that of ESI provisions. You understand? To whom and all ESI provision is applicable? To those persons whose gross monthly wages is 21,000 or within. When such number of employees in the establishment who are earning within 21,000, to all of them it is applicable. Correct? When it is applicable, Then at what rate employer should contribute, employee should contribute? I mentioned while explaining that, I have mentioned it like employer will contribute 4.75 and employee to contribute 1.75. This was earlier. Now, okay, earlier the contribution rate was in respect of those employees to whom Esi Act is applicable. This is very important. Employer will contribute in respect of each of the head of such employees 4.75% of his gross, and 1.75 to be contributed by the employees. But now that is not there. It is now modified, altered with effect from 1/7, that is 1st of July 2019, and it is reduced from, earlier it was totally 4.75 plus 1.75 is equal to 6.5%. But now this is not good. It is altered, amended, and it is reduced. The employer's contribution part is reduced to 3.25%, and employee's contribution part is reduced by 1.75%, and totally now it stands like 4%, right? With effect from 1/7/2000. So this is for your information, and earlier I have told that it is 6.5. It is not 6.5. It was 6.5 up to 30th of June 2019, but now it is 4% since from 1st of July 2019. The current rate of contribution to be contributed in respect of each of those employees who are covered by Esi Act, Esi scheme, employer to contribute 3.25 in respect of each of them, and each employee will contribute only 0.75%. Totally, therefore, 4%, reduced by 2.5 as against the previous scale. Right? This is for your information. Kindly make that correction to my lecture that I have given.